Hello there. I am Black Bright News. Call myself Black Bright News because I used to run a magazine called Black Bright News. So if you want to Google that, you can. But I stopped doing that and I started kind of doing Black Bright News in person. So it's basically I talk about different topics that I find in the news that I find useful, and then I give my opinion or raise any concerns about it. So today I wanted to talk about the Renters Act. Yeah, the Renters' Rights Act gives rights to renters, and the landlords are feeling a bit dishevelled, I think. And why is that? Because I guess if you're getting a tenant in, you'd like to know you can get them out. I don't mean unfairly or, willy nilly or for no reason, but you would like to think that when you take a tenant in, you dictate the terms. Well, the Renters' Rights Act has changed that quite considerably. And so there is no fault eviction anymore. So, how do you get rid of a tenant that's in your home and you want your house back? Well, I think the reasons that they are giving that allow you to do this are quite valid. So, let me read from my notes so I don't miss anything, because when I ad lib, I tend to miss and I lose out on the time. So, what to expect from the Renters' Rights Act, May 2026? Now that no fault evictions have been abolished, how do landlords evict tenants? Under Section 21, landlords could give tenants notice, a Section 21 notice, telling them to leave and start possession proceedings, even if the tenant had done nothing wrong. It's called no fault because the landlord does not need to prove that the tenant violated any part of the tenancy agreement, e.g. by damaging the property or not paying rent. So, the no fault evictions end. Well, it's abolished under the Renters' Rights Act 2026. So, what counts as a valid ground for eviction under the new system? Well, a landlord or family moving in. This is a mandatory ground. If proven, the court must grant possession. It has been widened. It's not just the landlord, spouse, or civil partner anymore. Close family members such as parents, children, grandchildren, or a partner living as married can now be included. However, this ground cannot be used during the first 12 months of a tenancy, and the notice period of 4 months must be given. There's also a restriction that if possession is gained on this ground, the landlord cannot relet the property to a non-family member or market it for at least 12 months. The second reason, sale of the property. So you can evict a tenant if you're selling the property. Selling the property is a new mandatory ground introduced by the Act, but the landlord must genuinely intend to sell the property, but cannot be used in the first 12 months of the tenancy. And 4 months' notice needs there. If possession is obtained on this ground, the landlord is restricted from reletting unless certain conditions, you'll have to check what those conditions are, for 12 months. Redevelopment, major works, another reason how you can validly evict a tenant. A landlord can use this ground if they intend to do substantial works, redevelop, construct, expand, or demolish part or all the property. You have to give 4 months' notice there. Antisocial behaviour and criminal conduct. There is a mandatory ground for severe antisocial behaviour, ASB, criminal behaviour. Don't know what they mean by severe. It doesn't look like if it's petty, it's not counted. So if a tenant has been convicted of certain offences or breached relevant ASB, antisocial behaviour orders, or where a closure order has been issued, that's a legal power used by the police or local authorities to shut down a property when it's linked to serious antisocial or criminal activities. So that can last from 48 hours to 6 months. This immediately restricts people from entering the property, so that's a reason to evict a tenant. The landlord can use this ground to evict tenants, and notice can be immediate in some cases depending on the offence or the order. Serious rent arrears. This remains a mandatory ground, but the threshold increases. Under the Act, the tenant must owe at least 3 months' rent if the rent is monthly for this ground to apply. Notice period is extended, 4 weeks' notice rather than 2 weeks under the old system. Importantly, arrears caused by universal credit housing payments may be disregarded for the purpose of this ground. Other grounds. There are many more grounds, both mandatory and discretionary. I'm not going to list them all, but I will say breach of tenancy agreement, subletting, damage, antisocial behaviour, less serious than ground 7A, failure to comply with tenancy rules. So notice and evidence requirements. To use any of these grounds, a landlord must serve the correct Section 8 notice, stating clearly which grounds they rely on and provide evidence in court that the ground is met. And for that, you can go to www.gov.uk for all of the information that you need. Because there's no more easy, no-fault route, the possession process may take longer. Court hearings will be required in most cases. Courts will also assess reasonableness for discretionary grounds. Just because a ground exists doesn't guarantee possession. The judge must weigh the circumstances. So you can go do all of this. The judge says no. So why these new changed grounds matter? These reforms strike a balance. Tenants get more security because they can't just be evicted without a reason, but landlords still have a strong, legally recognised reason to ask for possession, especially where there is a genuine need like selling, moving in, serious rent arrears, antisocial behaviour, redevelopment, stuff like that. The changes also try to prevent abuse, restrictions on reletting, family move-in or sale grounds, plus higher notice periods and evidential standards. Because, I mean, you could say, oh, I'm selling my home, and then you can say, oh, it didn't sell. I had it on the market for 6 months or whatever, and it didn't sell. You're going to have to evidence that, you didn't have any views, that you didn't refuse any offers, that kind of thing. It's not going to be just a question of you deciding that you're going to put the house on the market to get rid of your tenant, because you'll probably have to keep them until you exchange contracts, and then you give them the 4 weeks notice. And you'd need to arrange those 4 weeks notice. I mean, you'd tell the tenant that you found a buyer and that they will need to start looking, but that tenant, I'm just assuming, wouldn't have to evacuate or leave the property until you've got your commitment that that sale is going through. So what else? And I think that is just to say, if anybody could say, oh, I'm going to move back in my house, and not actually want to move back, and in the end you end up renting somebody else and charging them more money. All of those things are going to stop because they will investigate seriously to make sure that doesn't happen. So those are the reasons. You can use them as you will, and try not to abuse them. The changes also try to prevent abuse, reduce restrictions on reletting, family, move-in or sale grounds, plus higher notice periods and evidential standards. And I think that is all I've got to say. I know that, if you do have a tenant in your house, the tenant wants to feel secure, you want to feel secure, it needs to have mutual benefit. But sometimes you can make mistakes, you can make poor choices, and so you have to weigh up the pros and cons. So I guess that's all I'm going to say for now. I hope you found this video useful, and I shall speak to you again. Take care now. Bye-bye.